Director of Traffic revoked the driver's license of Mark J. Manis for a period of 1 year for failing to submit to a chemical test following an arrest for driving while intoxicated. He filed a petition for review. After a hearing, the Commissioner determined that the arresting officer lacked probable cause to believe that he was driving while intoxicated. The judge adopted the Commissioner's conclusion and entered judgment restoring his license. The Director appealed. The Director called one witness, the arresting officer of the Chesterfield Police Department. The officer testified that on January 1st, 1999, he saw a pickup truck on the shoulder of Highway 40 with the engine running. He pulled behind the truck and saw the occupant sleeping in the passenger side of the cab. The officer approached the passenger side and woke him. According to the officer, he said that he was looking for the police station and gave the officer a passport for identification. The officer noted a strong odor of an intoxicating beverage and testified that his eyes were watery, glassy, and bloodshot. He testified that when he got out of the truck, he used the passenger side door to keep his balance. The officer noted that the front tire of the truck was flat and there was some damage to the wheel rim. The officer testified that he said he had fallen asleep while driving and struck a concrete barrier. The officer arrested him for driving while intoxicated. Because of adverse weather conditions, the officer transported him to the police station and performed field sobriety tests. He advised him of the implied consent law and asked him to consent to a chemical test for blood alcohol. The statutory term chemical test can refer to the breathalyzer or a test of a sample of the person's blood. He informed him that if he refused to take the test, that his license would be revoked for 1 year. He refused to take the test. During cross-examination, the officer acknowledged that he had not seen Hannah in the driver's seat. The officer testified that from the odor of alcohol from Hannah, he could not determine the quantity or quality of that alcohol, and he could not determine whether Hannah was intoxicated. He also said that Hannah's bloodshot eyes could not lead him to the conclusion that Hannah was intoxicated. The officer also acknowledged that Hannah might have needed to balance himself with the truck door because he had just awakened and needed a period of time to balance himself. Hannah called two witnesses. The first testified that he had been driving, not Hannah. He testified that he was driving when he hit a pothole which flattened a tire. He walked down the highway and someone picked him up and dropped him off at a gas station where he used a telephone to call his brother to pick him up. The second witness for Hannah testified that he met his brother at the gas station and they drove to where he had left Hannah, but Hannah was nowhere to be seen, presumably because of the arrest. The trial court concluded that the officer did not have probable cause to arrest him for driving while intoxicated. The record does not disclose any request by the parties for findings of fact and conclusions of law. The object and purpose of the implied consent law is to rid the highways of drunk drivers. Shine versus Director of Revenue, 807 Southwestern Reports, 2nd, 160, 163, Missouri Appellate Court, 1991. The implied consent law was adopted to establish a fixed standard for procuring admissible evidence of blood alcohol for use against persons operating automobiles while intoxicated. State versus Paul, 437, Southwestern Reports 2nd, 98.